Good afternoon, everybody. I'm Stephen Pike of Gowling WLG, and it's a pleasure to welcome you to our webinar on S-211. We'll be starting momentarily, and I just want to let you know that we will be taking Q&A at the end of our formal presentation. You can see at the bottom of your screen a link to Q&A. Feel free throughout the presentation to pose your questions, and then we'll get to you. We'll try our best to get to you at the end of the presentation. So welcome. Canada's first ESG reporting legislation, S-211, is now been passed by the House of Commons and the Senate and will come into force on January 1, 2024. It requires companies in scope to report on the steps that they've taken to prevent and reduce the risk that forced labor and child labor is used at any step in the production of goods by the reporting entity or of goods imported into Canada by the reporting entity. As you may know, there's tens of millions of people trapped in forced labor and child labor around the world. And that's what this legislation is intended to shed some light on. Many of those are thousands of miles away from here, away from Canada. But as we saw in the news reports in March, there is forced labor in Canada. In March, 64 Mexican nationals were rescued by police in Ontario who've been working on farms and factories in Toronto, Mississauga, and Vaughan. They're subject to coercion, exploitation, isolation, threats, and sexual assault. So when we think of forced labor and supply chains, sometimes those supply chains don't extend around the globe. I'd like to introduce our special guest today, Senator Julie Miville-Dechêne. Senator Miville-Dechêne was appointed to the Senate in June 2018 after a successful career in the public service sector. She spent 25 years working as a reporter and was a foreign correspondent for Radio-Canada in Washington, D.C. from 1994 to 1998. In 2007, she became the first woman ombudsman of Radio-Canada, and in 2011, she was named chair of the Quebec government's Conseil du Statut de la Femme. Since her appointment, Senator Miville-Dechêne has introduced Bill S-211, which we're going to talk about today, and which became law this spring. She also has had the Senate adopt Bill S-210 that would require the implementation of age verification methods to protect minors from exposure to online pornography. She is co-chair of the all-party parliamentary group to end modern slavery and human trafficking. We're going to hear from Senator Miville-Dechêne in a moment. Let me just walk you through what our agenda is for this afternoon. We'll hear from Senator Miville-Dechêne on the impetus for Bill S-211, and then we'll have a look at the global legislative and regulatory context for Bill S-211 and into which Bill S-211 came to fruition. We'll then hear from Senator Miville-Dechêne about Bill S-211's legislative and political process. We'll then move into the basics of S-211. What businesses or organizations does it affect? What do they have to do? When do they have to do it? Then we'll talk about first steps for businesses, some thoughts on what businesses might do to get started in their S-211 journey. So let's start with Senator Miville-Dechêne looking at the impetus for Bill S-211.
Thank you very much, Stephen, for inviting me first. and for helping me all along during this 3 years. Stephen has been an advisor in many ways, has been talking to us. So this was really important for us. So let's go back to our topic. Obviously, the real context of this bill is not political or legislative, but first and foremost, humanitarian. 27.6 million people are in situation of forced labor around the world, and this is an upward trend. So there are definitions of forced labor. It's not, purely exploitation. It has to be work exacted from any person under the threat of a penalty and for which the person has not offered himself or herself voluntarily. Those threats may include, for example, debt bondage, but they may be numerous. But there are definitions in the international law and also in the bill you have in front of you, in the law, I should say. So a few statistics will help us, I think, to understand a bit more what we're talking about. 43% of victims are women and girls. The majority are men and boys. 12% are children. And by sector, if we exclude sexual exploitation, 63% of forced labor is in the private sector. And 14% of state-imposed forced labor. So this is out of your reach. So this is why we must act for reason of human rights and human dignity, and because we are complicit, sometimes unknowingly, obviously, but we are complicit in these violations through the goods we import and that we consume. So politically speaking, because I'm a parliamentarian, the final passage of S-211 marked the end of a long and complex process, 3 years, with many moving parts. And the background is important to understand. There were international precedents of legislation focusing on forced labor in supply chains. Let's think about United Kingdom, Australia, France, Germany, and the Netherlands. A hard-hitting report from a House Parliamentary Committee on Child Labor, especially called on the government to act. And the original predecessor to Bill S-211 was introduced by MP John McKay in 2018. So this is a while ago. John McKay has been my close partner in this long journey. Finally, I would mention World Vision, which is an NGO that had been involved in trying to eradicate forced labor and child labor, especially for over a decade in Canada. So a lot of people are behind this push. So much has happened since 2018. First of all, we had the pandemic, and I have to say, and it's sad to say, that it contributed to help S-211 to become a law, because many reports indicated that this pandemic led to an increase in forced and child labor because of strained supply chains and global demand for certain products. In Canada, for example, you probably remember the scandals of the Supermax glove in Malaysia. The Canadian government had ordered for millions of those gloves without due diligence, and obviously when we learned through the United States that they were allegation of forced labor in the fabrication of those gloves, it was very embarrassing for the government. Also, a lot of news investigation of common shopping items, canned tomato coming from China by Uyghur, also from Mexico, clothing. So forced and child labor, and there were some real good investigation on that. So essentially, the issue had become more visible with the pandemic. So after many failed attempts to move legislation, there were election, prorogation during this pandemic, there was finally momentum. Why? Because modern slavery legislation was promised in the election of 2021 by both liberal and conservative parties. So there could not be a partisan fight around it. Both were saying they had to act. Bill S-211 was improved and quickly reintroduced after the 2021 election, and the modern slavery legislation was included in Labor Minister mandate letter. You may think this is not that important. It is. When in their mandate letter, the ministers have something to do, they generally put it as a priority. So after that, the Senate process moved quickly, and the bill was passed by the Senate in April 2022, only 5 months between first and third reading. The House process, however, took more time, about 1 year, for reason of process and some hesitation from the government, I have to say. Minister drafted some amendments, including some that would significantly alter the bill, but in the end they were pulled because that would have meant going back to the Senate and threatening passage. So it was a compromise. This is what you have to understand. And in the end, it was decided to not let the perfect be the enemy of the good. This is why we have a bill today. So Stephen, your turn.
Thank you very much, Senator Miville-Dechêne. That was a great summary of how we got to where we are today. And I think it was a big step forward for Canada. Next slide, please, Bob. But S-211 wasn't created, S-211 and its predecessor was not created in a vacuum. As you can see here, and there are more that we could have added to the slide, but many of Canada's biggest trading partners and investment partners had already taken steps to deal with or to enact legislation dealing with forced labor and child labor and supply chains. And so at the time S-211 was coming forward, Canada was not on the radar. So
we were late, as you say. We're not on the radar, and we were very late in acting.
Thank you. And what some of the critical things that happened that led up to S-211 occurred in the UK with the in the UK with the Modern Slavery Act of 2015, and in the US. There had always been, from the 1920s, a prohibition on the importation of goods made with slave labor or forced labor. But there was an exemption called the consumptive demand exemption, which said if goods were not produced in sufficient quantities in the US to satisfy consumptive demand, then they could be imported from other countries, even if they're made with forced labor. So that went into effect back in the 20s. In 2016, President Obama, by executive order, got rid of that exemption. So the ban on forced labor goods being imported into the US came back into force, and US Customs and Border Protection began enforcing the ban. And I think that was, from a North American perspective, a big influence. But looking at this list, what I want to draw your attention to is they illustrate 3 tools that Western governments have used to deal with forced labor and child labor and supply chain. The first is supply chain transparency reporting legislation, as in California, in the UK, and in Australia, and now S-211 in Canada. And that requires companies to report, and depending on the legislation, it will also mandate specific reporting requirements or not, require approval by boards or not, et cetera. So that's a reporting obligation. The second tool is we'll call human rights due diligence legislation, which you'd see in France, in Germany, in the Netherlands, and also upcoming in the Corporate Sustainability Due Diligence Directive in the EU. And what this legislation does is make companies, so for example, the Corporate Sustainability Due Diligence Directive makes companies responsible for adverse human rights impacts caused by, contributed to, or directly linked to company operations or the operations of those with whom the company has a business relationship. So in other words, when we talk about due diligence in North America, we think about an investigation, an audit, an inquiry to confirm a given set of facts. When we talk about human rights due diligence legislation in Europe, we're talking about something different. We're talking about that investigation or that inquiry, but we're also talking about a duty of care to carry out the due diligence and be accountable for any adverse human rights impacts. And those laws generally do not have a financial limit on liability. So that's the context in which S-211 has come to be. Let's go back to Senator Miville-Dechêne for a moment. Next slide, Bob. Wait, sorry, I missed this slide. That was the third tool, which is import bans. I talked about what President Obama did. In 2022, a new law came into force in the US called the Uyghur Forced Labor Protection Act. And what it did was ban, not only ban, but deem any goods made in whole or in part in the Xinjiang Uyghur Autonomous Region or made by labor from that region. They're deemed to be forced labor made goods and are prohibited from entry into the United States. The first anniversary of the UFLPA was last Wednesday, and US Customs and Border Protection published a release noting that it had stopped nearly 4,300 shipments of goods with valued at just over $1.7 billion Canadian. You may or may not know that Canada already has a ban on the importation of goods mined, manufactured, or produced wholly or in part by forced labor under the Tariff Act, which was amended July 1, 2020, in connection with the implementation of CUSMA or the USMCA. This ban has been in place, and those goods are prohibited from entering into Canada. That's critical because companies that are having to report under S-211 based on their importation of goods into Canada should already be taking steps to ensure they're complying with this Tariff Act prohibition. So it's quite clear there's a big difference between what's going on in the US and the aggressive enforcement. And in Canada, under this Tariff Act amendment, there has not been one successful seizure of forced labor made goods. Okay.
Exactly. Yeah, exactly. And this imbalance is worrisome because at one point, will some ships be rerouted to Canada because our laws are not enforced? In this case, not only we have a law that's not enforced, but we have a difference in the law that make it much more difficult in Canada to arrest and investigate a boat with shipment that could contain forced labor. But let's go back to our topic, which you really set the table well, Stephen, on the question of transparency versus due diligence. And I want to come back to that because this whole controversy or this whole difference of approach in the world between the transparency legislation and the due diligence one arrived in Canada and was included and became the main debate around S-211. To be clear, some NGOs were very loud in saying that our bill was nothing, had no teeth, that what we should have is a due diligence bill right away. And this was, I would say, a difficult debate because obviously, as myself, a defender of human rights, I'm completely against forced labor. The idea was, what should we do? Should it be a step-by-step approach? Because in Canada, there had not been any legislation of that kind. Or should we go right away to due diligence, which is obviously an efficient way of combating slave labor, but if you look at the French law, only about 200 huge companies are included in the bill. And here in Canada, we have a softer, a more modest bill, but that includes more companies. So it's a different approach. So in our political debate here, other issues were raised. So the final legislation is still a transparency bill, despite the attempt of the NGOs to transform it. It includes improvements over other transparency legislation in the world. It's important to note that we have financial penalties in our bill for companies who mislead the public in their report. And that opens the door to litigation or class action. Stephen Pike knows those risks much better than me, so I will let him talk about that. We have also harmonized the bill with other transparency legislation in Australia, in UK, for example, by adding group reporting, equivalent statements, similar reports between all the countries that have transparency legislation to make the job a little bit easier for companies. And as I was saying, it represents a compromise between the demands of the NGOs for a broader and more severe bill and the demands of business for a more pragmatic, gradual approach. We reflected also on what definition of child labor should be in the bill. We could have limited it to the worst form of child labor, but we chose to include time for schooling. So you can see in the bill, which will be in the chat soon, that the definition is a bit wider than the one on the worst form of child labor. And also the bill asks companies to consider remedial measures for families when firing an employer who is too young may have a great impact on the family. So the whole board also has to approve the report, and there's an inclusion in annual report to shareholders of the efforts to combat forced labor and child labor. And this is for Canadian companies under federal jurisdiction. So there was a lot of tension, as I said, but in the end, the bill was not amended greatly, either in the Senate or the House, and it received royal assent on May 12, 2023. So what's next politically and in terms of legislation? The process may not be over. You may or may not have heard about that, but in the 2023 budget, the government said it would introduce legislation by or in 2024 to, and I quote, improve and strengthen the legislation. So nobody's exactly sure what it means. It could be an attempt to satisfy the NGOs that have pushed for a due diligence bill. In the end, the NDP voted against the bill because they did not think it went far enough. So it could be that. It's a very short delay for legislation. Nobody knows exactly what the government has in mind with this. So what's next? As far as regulation and implementation, the ball is now in the government court. It's no more in Parliament. They must develop regulation, guidance, set up public registry, public information on compliance, etc. I did ask publicly Minister Miville-Dechêne when a phone line would be in place for businesses, because we receive a lot of questions in our office. I didn't have an answer. So that process has been slow, too slow in my mind, considering government has known for more than a year before passage that this bill, S-211, would become law. Back to you. Steve.
Thank you very much, Senator Miville-Dechêne. The one thing I would just mention in terms of the senator's comments is that Bill S-211 also requires federal government departments, crown corporations, and federal agencies to also report on the risks of forced labor and child labor in their
Yes.
supply chains.
Thank you for adding that. I forgot to mention it, and it's important. It's an improvement over the UK transparency bill, which does not touch government. In Australia, they do. But a lot of businesses that told us when we were doing consultation, what about the government? Why is the government not included in the first version of S-211? And they had a point. Why ask companies to look into their supply chain and to be diligent about it? And the government, who is a big buyer abroad, not do anything? So we added that part, and the government will comply, and it will set an example for the others. And should, I say, I don't know if they will, but they should be an example.
Oh, thank you very much. I agree with your comments. For sure. So let's do this. Let's take a bit of a deep dive into what I call the basics. And there are a number of questions that I've heard, that Senator Miville-Dechêne's heard, et cetera, and thought we could answer them right now. So which businesses are subject to S-211 and which have to prepare, file, and publish an annual report? So there's a two-stage process to determine if a business or other organization has to prepare and file the report. The first question is the business, and I'll refer to that businesses as anything that would be could include or unincorporated organizations or partnerships or trusts. So which businesses are subject? So the question is the business what's called an entity under the Act? So if it's listed on a stock exchange in Canada, no matter where it's incorporated, that business is an entity for the purposes of the Act. If that, and so that's the public company side of things. On the private company side of things, or companies that are listed on another stock exchange, does it have a place of business in Canada? Does it do business in Canada? Does it have assets in Canada? If it does, then we have to look at a financial threshold, which is based on the entity's consolidated financial statements. Does it meet at least two of the following three criteria in at least one of its two most recent financial years? So 20 million Canadian in assets, 40 million Canadian in revenue, or an average of at least 250 employees. So if you meet that financial threshold and you're carrying on business in Canada, have assets in Canada, then you're an entity for the purpose of the Act. But not every entity has to prepare, file, and publish the report. To become what I call a reporting entity, you have to produce, sell, or distribute goods in Canada or elsewhere, import goods into Canada, or control an entity that is producing, selling, or distributing goods in Canada, or importing goods into Canada. So if you meet that threshold, you're a reporting entity, and that's the kind of business that we're going to talk about for the next few minutes.
And if I can interject one precision, we're talking here about goods and not services. So this is important to know, because in some others transparency legislation, services and goods are included. We chose a step-by-step approach. So for now, this legislation touches on goods, and we're aiming at big companies and quite a few mid-sized companies with those thresholds.
Thank you for that, that clarification. So what must be included in the annual report? Essentially, the Act first says that reporting entities have to set out the steps the reporting entities taken during its previous financial year to prevent or reduce the risk that forced labor or child labor is used at any step of the production of goods in Canada or elsewhere by the reporting entity, or goods imported into Canada by the reporting entity. So the key takeaway from what I just read are the words steps that the reporting entity has taken during its previous financial year. So it's retrospective in terms of what's going to go into the report. There's no prohibition on adding future-oriented information, but the requirement is for what happened in the last fiscal year or financial year for the corporation. So what else has to be included? Its structure, activities, and supply chains, its policies and its due diligence processes in relation to forced labor and child labor, the parts of its business and supply chains that carry a risk of forced labor or child labor being used, and the steps it's taken to assess and manage those risks, any measures taken to remediate forced labor or child labor, any measures taken to remediate the loss of income to the most vulnerable families that results from any measure taken to eliminate the use of forced labor or child labor in the business activities and supply chains, the training provided to employees on forced labor and child labor. And the seventh one I want to focus on, it says how the reporting entity assesses the effectiveness in ensuring that forced labor and child labor are not being used in its business and supply chains. And when I read that as a board issue, given the board's responsibility to oversee risk management. And this question is, how effective is the risk management program? So I see that rolling up to the board, and we'll talk about that in a minute, but that's a board issue. So keep that in mind as we move forward. The next question, next slide, Bob. The next question is very timely. What's the role of the board of directors? So within the words of S-211, the board's role is to ensure that a report is prepared, published, and filed. It's to approve the report and to have a member of the board of directors sign an attestation saying the board has approved the report. Now, what we're talking about there is simply what's within S-211. Obviously, there are other duties that boards and that directors and boards have to address, and we'll talk about that in a minute. So will the supply chain risk report be publicly available? The answer is yes. So first, supply chain risk reports have to be filed with the Federal Minister of Public Safety and Emergency Preparedness, and the minister has to post those on a to-be-created electronic registry that it will maintain, that'll make these available at no charge, I assume, to anybody who wants to read them.
And this is the transparency part. So you can see that a lot probably of NGOs and curious people are going to go and look at those reports to see if they are done seriously. You can go and have a look at the Australian registry, which is very well done, and will give you an idea of what's public. And obviously with publicity, with the public register comes the issue of reputation.
Absolutely. And well, reputational risk is key in terms of the reports. The reports also have to be posted by the reporting entity in a prominent place on its website. And if the reporting entity is incorporated under a federal statute, then it must provide the supply chain report to each shareholder along with the annual financial statement. So we're seeing three opportunities for the report to be available to the public. And in my view, that these reports being available is fully aligned with the growing demand on businesses for investors, lenders, consumers, other stakeholders for ESG reporting and more transparency as to ESG risks and how businesses are managing them, including the oversight of ESG risk management by boards. So we will definitely see these reports being available. Are there penalties under S-211? Senator Miville-Dechêne has alluded to them. So penalties for failing to file a report, failing to have it approved by the board, failing to have it signed by a director, those are all offenses under the Act.
Failing to, well, if you try to mislead intentionally citizens through this report, this is also an offense punishable by a fine of about $250,000 maximum. So it has to be well thought out. You know, if you really are blind and you know you're blind and you mislead not tell the truth, there will be consequences. There could be consequences.
And among those consequences, for those who are following news reports of investigations and inquiries by the Competition Bureau into greenwashing based on statements that organizations or businesses or other institutions have made, we can, under the E in ESG, I think that there's a risk that this may become something to that complaints may be filed with the Competition Bureau under statements made pursuant to S-211. So there is serious concern about what the consequences will be of misleading statements in the report. The last thing I'll mention about these penalties is that directors and officers who direct, authorize, assent to, acquiesce, or participate in the commission of offense may also be personally liable. So boards and the C-suite need to be really focused on ensuring that the report is prepared, that it's accurate, that it's complete, that it's filed, and that it's published. So that's a deep dive into S-211. And next slide, please, Bob. First steps for businesses. This is really my own personal view on what businesses should be considering. Looking at the fact that under S-211, the board has to approve the report that's required. In my view, the journey of S-211 will end at the board meeting when the board approves the report under S-211. And in my view, I think that's a place that where businesses should start, that it should start at the board level. Why should it start at the board level? Well, to be clear, S-211 does not mandate conduct of businesses beyond the reporting. So, and the reporting is only one facet of what the board needs to be doing from a governance, strategy, and risk management perspective. The report is merely, as I mentioned earlier, a retrospective report of what the board, of what the business did in the last financial year. So when we look at the role of the board, we need to ensure that the board is on top of what's going on in the business. And so when we look at the board, we know the board oversees risk management. We know that the board ultimately is responsible for strategic planning. And we know that the directors are subject to fiduciary duties. And in terms of those duties, we're talking about the duty to act honestly, in good faith, with a view to the best interest of the corporation. It may be a challenge to rationalize the best interests of the corporation with the use of forced labor and supply chains. As well, the duty of care that directors have to exercise the care, diligence, and skill that a reasonably prudent person would exercise in comparable circumstances. I would say same issue about rationalizing what a reasonably prudent person would do in terms of the use of child labor and forced labor and supply chains. So these are issues that are at the board level and have to be dealt with by the board. And I would just, reinforce that with some recent reports or commentary that BlackRock had published in March, where they looked at human rights as an investment issue. and took the position that long-term investors benefit when companies provide robust disclosure on these processes and when they implement processes to identify, manage, and prevent adverse human rights impacts that could expose them to material risks. So BlackRock on one hand wants more information and thinks investors, long-term investors, will benefit when they implement processes to deal with these adverse human rights impact. The same time, the same month, BlackRock issued a commentary on board quality and effectiveness, and reiterated that an effective board's responsibility was providing oversight on the identification and management of material risks and opportunities in the company's business model. So again, we've got to focus on the board and a focus on managing risk with respect to forced labor and child labor and supply chains and other human rights risks. So let's take a quick look at specifically at risks that the board has to deal with that relate to forced labor and child labor. Bob, next slide, please. So I put together a small array here of it's not comprehensive, but of risks that boards face in terms of forced labor and child labor. And you can see that the risk that I've noted in red at the top relates to regulatory compliance and reporting. So when you think of the S-211 report, you're thinking, well, to what standard is the board preparing this report? There's no global standard that's recognized in all countries in terms of this kind of reporting. Will there be assurance that the board can be provided when it's approving the report? What are the legal characteristics of the S-211 report other than compliance with S-211? I mentioned the Competition Bureau's views on greenwashing. Perhaps there are others. There's no safe harbor for the report under S-211. Under the California Transparency and Supply Chains Act, the courts have ruled that that report is, there's a safe harbor and companies can't be sued under consumer protection statutes, for example, for misleading consumers about their business activities. And then finally, I note what Senator Miville-Dechêne has mentioned, and I've mentioned about directors and officers' personal liability. So we're seeing this as and you see it in S-211, the issue of the risk of forced labor and child labor in supply chain. And that's something that the board of directors owns at the top level and is responsible for ensuring that it's taken care of in an appropriate manner. Next slide, Bob. So some suggestions or thoughts in terms of what would be the first couple steps that businesses should take. And the first step I would think about would be what's the business's and the board's position with respect to forced labor and child labor in business operations and supply chain. Is it condoned? Have they acquiesced to it? Or have they taken steps to prohibit it? And that's really, something that board needs to think about. And the answer to that question will be something that guides the preparation of the report under S-211 because it's only reporting on what the business does. And the question is, okay, will the board ensure that the business has taken steps to eradicate, I'll use the word the federal government uses, eradicate forced labor and child labor from its supply chains. So that could be adopting a policy or code of conduct or having management do that to prohibit the use of forced labor and child labor in its business operations and supply chains. Next slide, Bob. The second step would be for the board to task management to conduct and ensure that appropriate ongoing risk assessment of the risk of forced labor and child labor in business operations and supply chains is happening. and one would anticipate that it would be an integral part of the business's enterprise risk management activities and its ESG strategy and plans. The risk assessment should identify areas in the business operations and supply chains where there's a risk of forced labor and child labor, a risk that's more significant in terms of severity, scale, or probability, and should prioritize these areas for enhanced due diligence, monitoring, verification.
And if I could intervene just a minute, we're running
Please.
a bit out of time. I would say right here that my main worry and my advice, and I'm not here to give advice, but it's not just a matter of regulatory compliance, a box-ticking exercise. It should be, I think, an authentic commitment to the issue, because reports, and we've seen some in other legislation, can be filled with minimal information, vague commitments, and box-ticking exercise is obviously not the way to do it. I'm sorry to interrupt. I just wanted to add this thought.
No, thank you very much for adding that. And it is an active role that the board and management has to play. And it is not something that can be simply down at a much lower tier in the business for a simple compliance exercise. By requiring the board to approve the report, it's up to the board to make sure that it's doing what as I always recommend, to say what business is doing, but do what they're saying. So there should be no gap between what the report says and what's actually happening on the ground. The one thing I'll just mention, by the way, before we leave the subject, is that with respect to S-211, there's also a provision in the Act that provides for the making of regulations prescribing other entities for the purpose of the definition of entity. So the scope may be wider, as well respecting the circumstances in which an entity is controlled by another entity. So that may be clarified in regulations. And again, with respect to what may be coming forward, let's talk about guidance. The last Wednesday, there was a posting on the federal government website of some commentary, very brief commentary about Bill S-211. I called it guidance. It was the first guidance. It's very cursory, but what we've seen in other jurisdictions and what we'd expect to see in Canada would be detailed guidance about the report to be filed under S-211 with some very thoughtful and helpful information for companies to discern how they should be reporting, what they should be reporting, and answering questions that have come up through the process. What's really interesting about this legislation is that the federal government also has to provide these reports. So one would assume that there's guidance being prepared for use internally by the government for all government departments, crown corporations, and agencies. And my expectation would be that the internal government guidance and the external guidance should be the same. So one would expect that that's being worked on and that will be made available.
And if I could add just a note of reassurance, because I looked at the experience elsewhere. Obviously, the companies should all do their best, but this will be a work in progress. The report the first year will not be the same as the report the second year. I think everybody's conscious that it's a learning curve, and obviously, this has been taken into account in the UK transparency bill.
I'm just going to supplement Senator Miville-Dechêne comment about a learning curve. So I've read literally hundreds and hundreds of reports under the UK Act, the Australian Act, the California Act. when the UK Act came into force, there was a report, a statement is what it was called, posted by one of the big four accounting firms. And it, as required under the act, the Modern Slavery Act, and it went into a very detailed qualitative and quantitative assessment of the risks of forced labor or modern slavery in supply chains, and explained how it had thousands of suppliers and it had to sort of narrow the scope of its assessment. And it came up with 70 key and top strategic suppliers. It looked at those top 70 key and strategic suppliers, looking at key areas like what were the goods and services provided, where were they manufactured, locally or domestically or offshore, were they manufactured or provided in a country with a high risk of modern slavery or human rights violations, were they provided by low-skilled or workers or migrant workers. So through this assessment, they came up with what they had to report on. And what they reported on of their 70 key top and strategic suppliers, 8 were high risk, 24 were medium risk. So that was the first report by that entity. And so when the senator says it's a learning curve, yes, it can be a learning curve, but the sooner that companies who have to report under S-211 begin the process of mapping their supply chains, carrying out due diligence and risk assessment, the better position they'll be in when they have to publish the report. And they may even be able to publish at that time steps they've taken to remediate or address any high risk or adverse human rights consequences that they've contributed to.
And you're right, efficiency and compliance is really important because, you know, my advice would be you have to show that this bill works, you know, and this means make good reports, make good faith efforts to substantially address the issue. And if it's done well, it will limit the appetite for a more far-reaching bill if you don't want one. So in a way, the ball is in your camp, if I can say that. It's a French expression. And it's the idea that you are the one filling those reports and trying, you know, obviously a good report, transparent report can be excellent for the reputation of a company. It can help, you know, it's not only compliance and more paperwork. I think it could help a company, could help with investors. So there is an argument for having good and reports.
And not to derogate from Senator Miville-Dechêne's answer, but going back to my earlier comments, the report is, you know, at a point in time, it's a picture of what happened or what steps the company took in its last financial year. The question of going forward and the question of improvement and enhancement of its effort is something that the board needs to ensure takes place. Before we turn to the Q&A, Senator Miville-Dechêne, do you have any closing comments?
No, I think I've said all what I want to say. Please leave a few minutes for all the people who are listening to us and their questions. Okay,
and let me start to answer some of the questions. We've got a very large number, and so I'm going to try and answer some of them, or so Senator Miville-Dechêne may answer as well. The first question is that many entities are asking about the form and manner of reporting and whether businesses can expect clarity on this prior to January. I think I'll turn it over to you, Senator Miville-Dechêne.
It's part of what a government is supposed to do. We are expecting clear guidelines for the reporting and obviously for companies to be able to function. So in the bill, there are general requirements You enumerate them very well, the 7, that have to be filled. But obviously, the government has to give some guidance. That's what we're hoping.
Thank you very much. The next question is, does the bill prescribe how the report is shared with shareholders? Is there a requirement for the report to be published with a management information circular for public companies? And maybe I'll take a stab at answering that one. The bill does not prescribe how the report is shared with shareholders, and nor is there a requirement for the report to be published with management information circular for public companies. For that to happen, my sense is that would be required under the Provincial Securities Act, and so pardon me. And
yes.
So
that's why we couldn't intervene, because it's a federal law. So there are some areas that we're not intervening in.
Thank you very much. Another question is, what's the responsibility of non-public companies, in which way they will need to report their due diligence? And the answer is, the Act definitely provides for non-public companies that have a connection to Canada, as I mentioned earlier, and that are required to report. And the private companies are expected to file reports under the Act if they're subject to the Act. If they become recording entities under the standards and thresholds that I noted earlier, then they will need to report the same way public companies do. The question is, the fighting against forced labor and child labor only refers to production, selling, or distributing of goods. Does it mean it doesn't apply to the provision of services?
Well, not in the bill, which doesn't mean there's no forced labor and child labor in services. The idea was to start with something easier, more tangible, but things could change. And obviously, it's not a bad idea to look at the whole picture from your point of view.
Thank you very much, Senator. There's a question in terms of, let me see this, sorry. Just going through the list here. Can the report content that is filed be paraphrased when adding content to the entity's website, or does the actual filed report have to be made available on the entity's website? And the answer for that, Senator Miville-Dechêne, is not yes. You must provide a link to the actual report,
which doesn't preclude you to to vulgarize it and to make it more understandable for your shareholders or for the general public. Nothing precludes you from making a short summary or all that, but the report itself has to be public.
Thank you very much, Senator Miville-Dechêne. And it is very clear, it's an important point, which is the Bill S-211 does not limit what businesses can say in the report. So if they have forward-looking plans and strategies about, for example, something they're going to do next year, they can certainly include that in the report, but they must also provide all the information that's required under S-211. I've got one last minute, and I'm just going to answer the question. Can you please repeat when reports are due and will need to be submitted? The answer is the Act will come into force on January 1, 2024, and all reports required under the Act must be submitted by May 31, 2024, regardless of the financial year of the reporting entity.
Yes, there was a lot of back and forth on that. What was the best date? Finally, there's no perfect date. And this was the one chosen because it's the majority of companies who have this date, but we know there's other date. But we all thought that it could be done, the research could be done separately from the financial reporting. So we'll see. But I realize this is a very short time between the coming into force and the first report.
Well, thank you very much, Senator Miville-Dechêne. I'm afraid that's all the time we have today. If you have questions or additional questions, please feel free to reach out to me or to Senator Miville-Dechêne. We would be happy to answer your questions. And we thank you very much for joining us today. It was a pleasure to be able to talk about S-211 with you and our special guest, Senator Miville-Dechêne. Thank you very much. Merci beaucoup.
Thank you for listening to us. It's pretty technical in some ways. Thank you.
Thank you very much. And we'll be signing off now.